Good evening, relatives, and thank you for joining us on the Native Pulse this evening. My name is Stephen Cheney, and I'll be the host this evening with a number of amazing guests from our relatives up north of the medicine line. We're really pleased and honored to have everybody here to be able to discuss the UN Declaration on the Rights of Indigenous Peoples, among many things involved in that. Today, specifically, on that note, we are addressing Canada's National Action Plan and the self-determination of First Nation peoples. The focus of our discussion tonight will be on Canada's qualified endorsement of the United Nations Declaration on the Rights of Indigenous Peoples and its domestication of the international standards and law through an imposed national reconciliation plan by pressuring First Nation peoples to enter into agreements band by band that essentially convert them from being Indigenous peoples into ethnic minorities with no right of self-determination. So some very important stuff to digest here, and thankfully we have some experts to do that for us. We have one of our 7th Generation Fund advisors, Russell Daibo, will be joining us this evening. Sharon Venn and Chief Judy Wilson. And before we begin, I just wanted to give an acknowledgement of Turtle Island. You know, all of our relatives, all up and down these lands, in every direction, and just really honor them and acknowledge their sovereignty and everything that comes with that. And so with that, relatives, I have the pleasure of first introducing Sharon Venn. And Sharon is a Cree woman. She has worked at the United Nations prior to the establishment of the Working Group on Indigenous Peoples in 1982. The background research to many clauses on the Declaration on the Rights of Indigenous Peoples is included in her book, Our Elders Understand Our Rights, Evolving International Law Regarding Indigenous Peoples. In addition, Sharon has written numerous articles and edited materials related to the rights of Indigenous peoples. She has lectured on the rights of Indigenous peoples in Australia, New Zealand, Norway, Sweden, France, Italy, Hawaii, United States, and Canada. Sharon worked to secure a UN study on treaties from the first introduction of the resolution in 1983 until the report was finalized in 1999. She worked to ensure that report reflected Indigenous laws and norms. So there's no one else that can introduce us in the way that Sharon can for this, and we are pleased to have you, Sharon. Thank you so much.
Hi. Nia no te kwa masko matoka. Peso askwa dodam. My name is Old Woman Bear, sitting next to the creator, and I'm from the Thunderbird Bear clan. I was asked to talk about the history of the work at the United Nations, and the reason that we went to the United Nations way back. I guess it goes back to the League of Nations, but I won't go back that far. I wasn't there then. But in 1972, there was something significant happened on Turtle Island, and that was at Wounded Knee. And our people went to Wounded Knee. I'm talking about Cree people went to Wounded Knee to support the Lakota people, because we have a long-standing treaty with the Lakota people that predated the arrival of the colonizers. Anyway, when people were there, like our relatives were there, one of the things that people started talking about was we have rights and obligations as Indigenous peoples, and they started writing them down in a document. And they got to, I can't remember, I think 14 points about, right of self-determination, right, right land, resources, and those kind of things. And so when, and most particularly about treaties. And in the same time, in 1972, the International Court of Justice, which is sometimes called or referred to as the World Court, handed down a decision in what they call Western Sahara, which was an advisory opinion that was asked for by the General Assembly. And in this advisory opinion, which dealt with the indigenous peoples of the Western Sahara, the International Court of Justice said that international law does not recognize, and it's not valid to use doctrine of discovery, terra nullius, or conquest as a way to legitimate access and use of indigenous territories, and that the only way that international law recognizes anything is that through agreements or treaties. And so this was a very big thing that was, known to our people. And so there was a movement to have a meeting about this. And it just happened that the United Nations was going through the second decade to combat racism. They're now in the fourth decade, by the way. So anyway, there was a lot of discussion about the racism directed at indigenous peoples. And in 1972, the United Nations also undertook a study, the COBO, what they became known as the COBO study. That took from 1947 until 1972 to get that adopted by the UN, because Canada and the United States fought all the way against having any work done on indigenous peoples. But in 72, COBO undertook the study. But in 77, there was the first, what they call the first Indigenous conference in Geneva at the Palais des Nations. And there's quite a famous picture of people walking in to the Palais des Nations. And there was no effort at that time, or nobody at that time thought we're going to the United Nations to get a declaration. We didn't think that anybody at the United Nations needed to write a declaration for us. We already knew what our rights were. Our big thing was about our territories, our resources, and our treaties. And that was our core messaging going forward. And so working on this document that from Wounded Knee was sort of like at the evening meetings, when we had evening meetings, we'd look at the document, and then as people from South and Central America joined in, or Aboriginals from Australia, or the Maoris, or other indigenous peoples from around the world started coming into the meetings, we would go through the document and say, here's what we've been working on. And then, I remember when Rigoberta Menchú showed up in the mid 1980s, she said, we need to put in there that indigenous peoples cannot be forced to serve in the military of these colonized states. And we said, oh, okay, well, we didn't have that issue, from where we were. So that was a good idea, so we expanded it. And in 1985, without our consent, I have to add, the document was taken out of our indigenous meeting and introduced into the UN system without our knowledge. And in 1986, the Working Group on Indigenous Peoples started saying they were going to elaborate a draft declaration. And from 86 until 92, we had to fight in order to try to maintain the original language that we had from 72. And it was a huge fight. And it was like we had, walkouts, we had, demonstrations, we had all kinds of things in the UN system that nobody had ever seen before. We had people from the higher echelons of the UN coming in and saying, you guys have to go to meetings. We said, no, we don't. We can do what we want. But because we're indigenous peoples, we don't have to follow the rules, because we're our own nations. So there was a real, and there's a popular myth that floats around the country. I know it's, on Turtle Island, it's also all over the world, that these state governments were not engaged in the development of the declaration. And that's a complete lie. They were in the room. They were fighting us every step of the way. I can give you names. I can tell you who they were, because I was there. And I heard them, I seen them, and they said, I remember Denny Morantz at one meeting, who was the Canadian government representative, him and Marilyn Whitaker, they're there and they're saying, yeah, okay, you might be able to get it through this system, but eventually we're going to get our hands on it, and then we'll fix it. And so there was always this process in the background. But what happened was that at the original part of the drafting, we had changed one fundamental rule in the UN system, and that was that the nations could represent themselves. They did not have to go through a non-governmental organization, as they call them.
Mm-hmm.
We did not have to do that. So if you came and you were representing your nation, you had a paper that says, or even some people from Central and South America, they brought like little things that that were wrapped in cloth and said, this is what the nation was given to me to be here to speak on their behalf, and the UN accepted it. So this was being drafted by the nations themselves. This was not a government orchestrated takedown in the working group. And what we had been able to negotiate was in the subcommission, which is the next body up from the working group, was that the members who had participated in the working group on Indigenous peoples could also participate in the subcommission in their own right, as was at that time the African National Congress and the PLO and all these other people. You could participate in your own right. And in the subcommission, so we got it through the commission, or we got it through the working group, we got it through the subcommission, and then at the Commission on Human Rights, we had been pushing for the same kind of access. And what the state governments orchestrated by Canada and the United States created something that never existed in the UN system before, which was the intercessional working group. And in the intercessional working group, they said only people who are in NGOs or organizations recognized by state governments could participate in the drafting or elaboration of the draft. And that's where things went off the rails, because then only people who could get money from state governments, who were recognized by state governments, could participate. So then you got AFN, you got the National Congress of American Indians, you got the ADSIC from Australia, you got all these different organizations started showing up in the UN, which had never been there before. Never been there before. All of a sudden they're showing up. They're well funded, so their name in the UN became the Gongos, which was the government NGOs were starting to control the process. And state governments were saying, yes, we have to deal with these people, and they're saying, no, they don't represent the people on the ground. Anyway, so they managed to start to manipulate the process, because so from 1993, when it was in the commission until 2007, there were people that resisted changes to the declaration. They could not make changes. Then the United Nations created the United States. This is a directive from the United States. They created what they call the Human Rights Council, replacing the Commission on Human Rights. And in the Human Rights Council, one of the first things they did was they passed the draft that the chairman had been working on from that intercessional working group, and they sent it to New York. And when it was sent to New York, the number of people that were in the room making decisions about the declaration was 7 people. 6 of them were unilingual Anglo speakers only. There was only one Spanish person in the room. And it was really those people decided and made decisions. And that's where you get Article 47. You get changes to the declaration, which added individuals into it. So the one, I don't know if you can see this, people should read Charmaine Whiteface's book, because Charmaine Whiteface is a Lakota. She's from Pine Ridge, I believe. Charmaine went through and she itemized each section, the original draft, what they try to do in the intercessional working group, and then what they did in New York. And you can see each article changed. Because if you look at the last article of the declaration that now exists, it says, what you have to do is look at Article 45, the original last document. It says, nothing in this declaration may be interpreted or as implying for any state, group, or person any right to engage in any activity or perform any act contrary to the Charter of the United Nations. And what does the Charter of the United Nations say? that all peoples have a right of self-determination, and that the purpose of the United Nations is to promote all people's right to self-determination. So that was the original 45. That was the end of it.
Mm-hmm.
So you see how it ends. It says nothing in this declaration, and that's the normal drafting of in the UN system. Nothing in this declaration. But if you read now the new 46, because they didn't amend the 45, what they did is they created a new article in New York. It says nothing in this declaration may be interpreted. So they didn't even amend 45. They make another nothing. May be interpreted to implying for any state, people, not peoples, group or persons, any right to engage any activity or to perform any act contrary to the Charter of the United Nations or constitute authorizing, encouraging actions that would dismember or impair or totally or in part the territorial integrity or the political entity of a sovereign independent state. Well, that's the problem. Because up until that time, the whole territorial integrity issue of international law was under great stress because of the breakup of the Soviet Union, the breakup of the former Yugoslavia. There was huge states that were falling apart, and the territorial integrity was becoming less and less of an issue until these Western states insisted that it be put in the declaration. And the reason that these 7 people in New York agreed to that was because state governments told them, if you don't agree, we're not going to pass it. But I wasn't there. But my reaction when I heard that was, well, then you should have just walked away.
Yeah.
Because we don't need this. Because we have our rights. We didn't go to the UN to have a bloody declaration. We had to fight for trying to keep the language we had from 72. So, the myth is that we went there to get a declaration. That's not true. But the other myth is that, Canada, United States, and these countries were not engaged. They were engaged. They were in the room. They were fighting, trying to figure out ways to undermine. I remember one time the U.S. brought in a couple of guys. They said they were indigenous or Indians from Florida. They didn't, anyway. And they were trying to tell us that we should have the blood quantum rules put into the declaration.
Wow.
It was a holy hell, and like it was a big fight. And we said, so it's going on and on. It's like 11 o'clock at night or something. I stuck my hand up and I said, okay, I agree. There should be a definition based on, in the declaration, which we had been fighting against for years and years. Said no. And so the people were like, 11 o'clock at night, people were all wigging around their heads and looking at me. And I said, yeah, I agree. It should be Crees and those that want to be Cree, full stop. And then the Mapuche guy jumps up and says, no, it should be Mapuche, and those that are Mapuche and those that are not Mapuche. And then the Maoris got involved, and and the whole thing became a big joke. These 2 guys from that said they were from the States trying to push this blood quantum crap on us. And you know what? Never seen those guys after that meeting. Never seen them. So they tried to manipulate. And so this whole idea that, we didn't get involved, and it was, they were just doing their thing. That's bullshit. Excuse my language, but the other thing I want to talk about quickly is that there's a whole misunderstanding of international law about the effect of a United Nations General Assembly resolution. The United Nations General Assembly passes tons of resolutions. And they've made all kinds of declarations, like there's a declaration on the rights of the potato, there's a declaration on, all kinds of things. But a declaration in the UN system is the lowest instrument in the UN system that relates to anything related to rights. And the declaration is not enforceable. There is no mechanism in the UN system to make it enforceable. So, why is everybody jumping on the bandwagon about a declaration? Because we have to remember, why did we go to the UN in the first place? Because of our lands, our resources, and our treaties. None of those things have been dealt with. They're still outstanding. And the declaration is now used a state smokescreen. Because why did we went to the international level for international rights? or to have our international rights recognized.
Mhm.
Now we're domesticating ourselves through this process because now we're saying to the state government, recognize us, but they didn't recognize us to begin with. So we left the country, we went to the UN system, and now we're being pulled back into the domestic scene and saying, come along, let us domesticate you. Let's tame you and incorporate you into the state. When our lands and resources are still an outstanding issue, because this truth and reconciliation crap that they're pushing out there. What's the truth?
Yeah.
The truth is that this is our land, these are our resources, and that they never ever had them because we never gave them up. That's the truth. And they cannot reconcile until they accept that. And they have never accepted that. So they're trying to run some kind of sideshow that says that we can reconcile with them. How can you reconcile with people that are lying all the time? It's not possible.
You're
So
exactly right.
I just want to go back to this issue about why people have to remember why we went to the
Yeah.
UN in the first place. Because right now, what the state governments have done in collaboration with a lot of some indigenous peoples, and I could name names, I could, because I know who they are. They have destroyed any mechanism within the UN system that would allow us to draft a convention, which is legally binding on state governments. There's no process in the UN system right now to draft a convention. So we've had to move away from those mechanisms that they created for us, the little playpens that they have, like the expert mechanism and the
Yeah.
permanent form. Those are little playpens. So we've moved, and Chief Wilson was there. We moved into CERD, the Committee on the Elimination of Racial Discrimination. They said our right of self-determination has to be protected. Our right to free, prior, and informed consent has to be protected. And in 2012, Canada was asked by CERD, produce the document or documents that show that you own the lands and resources of the Indigenous nations that are presently within the state of Canada. There was nobody. There's nobody that could give that answer. They have never produced a piece of paper.
Yeah.
So this is still a live issue. And that's why we have to be very careful about what they're trying to do now. Because I think, in my mind, what Trudeau's trying to do is he's trying to talk our people into giving our consent to something that we should never consent to. And people that don't know the history of the UN and the work that we did are going to go along with the program. And that's going to be dangerous to the future generation. I think I probably
Exactly.
talked enough.
Exactly like you said. It seemed there are so many. I like the way that, first of all, thank you, Sharon, for that wonderful intro and just so full of knowledge. And I think you said to remember what is the reason that we went there in the first place, and to not get caught up in these playpens that exist. So thank you so much.
Thank
Uh,
you.
Next, we're going to I would like to introduce and have the pleasure to introduce Russell Daibo, the Mohawk Nation at Ganawake. Did I say that right, Russ?
Yeah, that's close enough.
Close enough. All right. Thank you. Russell has worked for Indigenous rights for more than 40 years. He was present at Wounded Knee during the 1973 standoff when he was 17 years old. He is recognized as one of the foremost Indigenous policy analysts in the country through his work as a writer and editor of the First Nations Strategic Bulletin, while continuing to work with the bands at the community level and with Indigenous activists in Defenders of the Land, which he co-founded with Arthur Manuel. So, thank you, Russ, for being here and for really doing a lot of this organizing behind the scenes. Just want to let all the relatives know you brought this conversation forward, and it's an important one, and for so many reasons. And we are excited for you to be here and to continue. So take it away, Russ.
Thank you. Well, I just want to thank Sharon and Chief Judy Wilson for agreeing to participate on this panel, because I really respect their views on these issues that we're all facing, especially here in Canada. You know, we have a different situation than what's going on in the United States now, even though we're still on Turtle Island.
Mhm.
The Canadian situation, I think a lot of people from, you know, the south of the Medicine Line, hopefully they'll get a better understanding of what's happening up here, because a lot of them think Justin Trudeau is a really nice progressive guy compared to Donald Trump. But I can say he wears several masks,
Yeah.
some black and some red. Anyway, what I wanted to talk about was how Prime Minister Justin Trudeau is using the UN declaration as cover to push his version of rights. They've weaponized the recognition of rights. If they don't recognize your rights, then, you know, as far as they're concerned, they don't exist.
Yeah.
You have to agree to their policy. So in other words, you have to negotiate what they call a modern treaty under comprehensive claims. You have to negotiate a self-government agreement, which is really their umbrella policy. Or you have to agree to get out of the Indian Act, which is the current foundation of colonial law that still exists in Canada.
Mhm.
And they have other laws you can opt into, like the land management, First Nations land management, fiscal. So in other words, they're controlling and managing us and the options out of the Indian Act through policies and through legislation. And one of the first things that the Liberals did, we had a federal election here in 2015. One of the things they had in their Indigenous platform was they promised to support or endorse and implement the UN Declaration on the Rights of Indigenous Peoples. But in 2016, they gave qualified endorsement to it. They said that they were, in one sentence, the Minister of Indigenous Affairs, as she was called then, Carolyn Bennett, went to the UN Permanent Forum and said that Canada gives unqualified support to the UN Declaration on the Rights of Indigenous Peoples. But then in her next breath, you know, she said that in accordance with the Canadian Constitution. And that's a qualification, because what that is based on is the constitutional division of powers in Canada between the federal and provincial government. There's no room for Indigenous nations in that constitutional framework.
Mhm.
So that's the basis on which they're saying they're recognizing the UN Declaration. In 2016, they also announced that they were going to do a two-track approach to like a common policy approach to Indigenous issues. So they've lumped First Nations issues, Métis issues, Inuit issues together in a common policy approach. And when they say two-track, they really mean one track being the status quo, where they're continuing their colonial constitutional authority from 1867 for Indians and lands reserved for Indians. And also they're trying to control the interpretation of Aboriginal treaty rights through Section 35 of the Constitution Act 1982. So those are the two tracks. They want to move everybody out of track one into track two. And that was, just a few months after they got elected into government. As part of that, in 2016, they established these recognition and self-determination tables, where they said you could talk about anything that you want. But then in 2017, they imposed these 10 principles on Indigenous relationships. The former Minister of Justice, Jody Wilson-Raybould, introduced those without consulting anybody on the content, including their so-called partner, the Assembly of First Nations. Mm. And those 10 principles are based on the doctrine of discovery that Sharon referred to. And also, although it doesn't specifically mention it, but it's also based on the Constitution Act 1867. That's that in accordance with the Canadian Constitution. That's the federal and provincial jurisdictions. There's no Indigenous jurisdiction mentioned there. Mm. And it's based on this assumed crown sovereignty. They're saying reconciliation is based on pre-existing sovereignty and rights of Indigenous nations, but in reconciliation, you go through this process of recognizing assumed Crown sovereignty. So basically, it's an extinguishment and replacement of rights policy. That's what's going on, but they have nicer wording for it. But it's cooked up by the Department of Justice lawyers. And that's what Sharon is referring to, is that, you know, they're trying to convince Indigenous nations and communities to accept this. I just quickly want to go through the 10 principles. Principle 1, they define, you know, they say they recognize the inherent right to self-government and self-determination, but, you know, you have to unpack that. The inherent right to self-government in 1995 was defined in a policy unilaterally by Jean Chrétien, who was Minister of Indian Affairs. It's still the policy today. It's the umbrella policy. And in there, they say what's on the table and what's not on the table. And it's basically, you have to harmonize your laws with federal and provincial laws. So it's basically turning you into like an ethnic municipality. That's what's in that policy. So when they say they recognize your inherent right, it means as defined and interpreted by their federal policy. And that's what they want you to sign self-government agreements under that.
That's number one.
And they use the term self-determination and self-government interchangeably. So, I mean, this is that domestication process that Sharon was talking about. Principle 2 talks about, you know, reconciliation being the fundamental purpose of Section 35 of Canada's Constitution. And it's in that section that says they recognize existing Aboriginal and treaty rights of Aboriginal peoples. But again, that means through their policies, it means surrender to assumed Crown sovereignty. Principle 3 talks about honor the Crown, guiding Crown conduct and relations with Indigenous peoples. Well, that's what Vine Deloria used to say is a legal fiction. It really doesn't exist outside of any courtroom and not in the courtroom either. Principle 4 recognizes that Indigenous self-government is part of Canada's evolving system of cooperative federalism and distinct orders of government. Well, they're putting that in agreements across the country, and it basically, again, is based on that self-government policy. When they say cooperative federalism, they're saying, Trudeau said in 2016 that Indigenous governments are the 4th level of government in Canada after federal, provincial, and municipal governments. So basically, they're saying you're at the bottom of this cooperative federalism, you're at the bottom of it, and then you're a distinct order of government with less status than a municipality. So, you know, that's what they mean in Principle 4. Principle 5 says Canada recognizes that treaties, agreements, and other constructive arrangements between Indigenous peoples and the Crown have been and are intended to be acts of reconciliation based on mutual recognition and respect. Well, we know that this is nonsense too. It's really about what they call post-1975 treaties under the comprehensive claims, like land claim settlement agreements is what they call modern treaties. And those only started with the James Bay Agreement in 1975. So the treaties that were signed with Great Britain before that, most of the treaties in Canada are in that status right back to pre-Confederation times. You know, the treaties of peace and friendship in the East, all the way through to the West. They don't have any way of really dealing with those on a nation-to-nation basis. They're trying to get the treaty nations to sign these self-government agreements to implement their treaty through these self-government agreements. And that's what they've got a number of treaty groups on the prairies at these recognition and self-determination tables, and that's what they're trying to convince them to do, is implement their treaty through self-government. I'm sure Sharon could add a lot more to that, but the principle about treaties is nonsense. Treaty 6, here's another example. They say that they aim to get free, prior, informed consent with Indigenous peoples. Well, even in the UN Declaration, Article 32 says states shall obtain the free, prior, informed consent of Indigenous peoples. So you can see they're watering down even, you know, the UN Declaration, you know, with this domestic Canadian definition of the UN Declaration. Principle 7 says any infringement on Section 30 rights must by law meet a high threshold of justification that includes Indigenous perspectives and satisfies the Crown's fiduciary obligations. Well, this comes from Supreme Court of Canada rulings about Section 35 rights, starting with 1990 Sparrow, where they said Aboriginal rights are not absolute and cannot be infringed for valid legislative reasons. So, I mean, Section 35 was supposed to be a political agreement when it first came in the 1980s. They ran out the clock on constitutional talks, and the court started interpreting Aboriginal treaty rights in Section 35 after that. So for the last 30 years, they've been adding legal tests, which are unaffordable because they cost millions and millions of dollars to collect the evidence.
Wow.
And you're lucky if you get a judgment in your favor. Anyways, you know, they've got other principles here. I won't go into them all, but they introduced those 10 principles to affect policy and law. So they've qualified what they're doing through those 10 principles. In 2018, they announced they were dissolving the Department of Indian Affairs, and they've created 2 new Indigenous departments, because what they're doing is they're getting rid of the distinct legal status that Indigenous or Indian nations have by mixing it in with this common Indigenous policy approach. And also in 2018, they tried to pass a rights recognition law, which was objected to by many First Nations across the country. But among other things, the proposed law proposed converting First Nations into having rights as a natural person, which in law means a corporation. So that got rejected. So what did they do? They started pushing that at individual negotiation tables. They passed laws in 2019 on Indigenous languages, Indigenous child welfare, and to create these new structures, the Indigenous Services Canada and Crown Indigenous Relations departments. And again, those departments are to move everybody from the status quo, you know, being Indian bands with unresolved Aboriginal treaty rights, into signing self-government agreements or legislation, you know, or land claims. And in 2019, Minister of Crown Indigenous Relations, Caroline Bennett, signed recognition of self-government agreements with Métis. And she's pushing the same template agreement for First Nations. Section 7 of the template, self-government or it's recognition and self-government, because they're saying if you want to be recognized, you have to come under our policy or law. So they're saying the legal status and capacity in the Section 7 of this template self-government agreement, as the self-government agreement implementation date, the First Nation X government and each of the governance structures will be a legal entity with the rights, powers, and privileges of a natural person at law. Again, in other words, a federal corporation. So, you know, we had a federal election in 2019, and they made a bunch of promises in their new platform. And one of their promises is they plan on introducing a law to implement the UN Declaration in this fall session of Parliament. And the Minister of Justice, who replaced Jody Wilson-Raybould as the minister, a guy named David Lametti from Quebec, is he's in charge. He has the pen. So the lawyers have control of the pen. So I think that this UN Declaration law, we have to see the text of it, but I think it's just going to be recycling what they couldn't get through in 2018 in this rights recognition law. I think they're going to bring it back up to be a one-window pan-Indigenous approach for First Nations, Métis, and Inuit, to say it'll be like a recognition act. If you want to implement the UN Declaration and rights, then this UNDRIP law will be the law that replaces the previous one they tried to pass, and they delayed because of the opposition. But they're peddling it at different tables. Like I just read you a clause from the self-government agreement they're pushing. So, you know, that's what's happening in Canada. Is I call it the National Termination Plan, but they're doing it band by band. So a lot of the chief and councils who are at these negotiating tables, they're also saying you have to keep these talks secret, so they don't even talk to each other. But the federal negotiators talk to each other, so they know what's going on across the country and how they're implementing their plan. And they have a federal steering committee on Section 35 to check that the national standards and that are being imposed, so that nobody from one region or a local negotiation table proposes something that upsets the whole national framework. So they have a national plan. We don't have one. So that's how they're picking us off, basically, community by community or band by band.
The divide and conquer.
And they're good at it. They're also using the money. They're coming up with a new fiscal policy. But the new self-government fiscal policy, that's the last thing I should say, is that if you sign a self-government agreement, you're going into a new fiscal agreement for self-government. And that's a formula, and it's the federal transfer payments are reduced, and you have to make up the difference in what they call own source revenue, which means taxation. Because in Canada, unlike in the States, on the reserves, property's tax exempt, and that means income on reserve is tax exempt too. But they've been wanting to remove that section of the Indian Act, which is where that's housed right now, to have everybody paying tax. And they're trying to get at that in different ways. So if you sign a self-government agreement, that's one of the things you're agreeing to do, is to get rid of that section and start paying taxes. Personal income tax, property tax, sales tax, all of it, just like any other Canadian. So you become basically an Indigenous Canadian.
Wow.
So that's how they're implementing UNDRIP in Canada.
Thanks for giving the update, Russ, and for providing that information, and for, again, I think just when you were beginning, you were also just letting all the relatives that are south of the medicine line, so to speak, to kind of like pay attention as well of some of these tactics that you're seeing happen right now.
Well, when I said national termination plan, I got that from the US, because I know it was a termination policy in the US, but I'm saying that
exactly
the Canadian government has its version of a termination plan and policy too.
Thank you, Russ. Again, for anybody that joined us midway, I'm Stephen Cheney, and I'm hosting our Native Pulse north of the medicine line. The start of hopefully many talks this evening, and we're talking about Canada's qualified endorsement of the United Nations Declaration on the Rights of Indigenous Peoples, and its domestication of the international standards and law through an imposed national reconciliation plan by pressuring First Nation peoples to enter into agreements band by band, as Russ has just said, as shared, that essentially convert them from being Indigenous peoples into ethnic minorities with no rights of self-determination. So very important stuff, information for us to take in as we go forward. And next, I'm very honored to introduce Chief Judy Wilson of Secwepemc ancestry. She comes from a long line of prolific leaders. Her uncle, late Grand Chief George Manuel, his brother, Grand Chief Joe Manuel, and her cousins, late Chiefs Bobby Manuel and Arthur Manuel, from Nisconlinth. Did I say that okay?
Okay.
Again,
Yeah, I just want
go ahead.
thank you for that introduction, and I want to thank you for the recognition of our many nations across Turtle Island that this message is going out to, and many of the ones that are struggling, the Micmacs right now on the East Coast about their lobster fishing, and our nations here in BC with the open pen fish farms, what's happening. Those are all the things we talked about at our Union of BCN Chiefs this meeting, or today we had a 52nd AGA. The fishing rights, the hunting rights, our harvesting rights, our protection of the forest, all of those things are really important, and they affect many of the nations. And so it's timely this discussion is coming out, because we're talking about proposed legislation federally. And what Sharon set out is a lot of the history, a lot of the things that happened, which state governments did already and are still trying to do to domesticate or to water down our Indigenous rights, our people's rights that we have. In our nation, we hold collective rights. So it's not held by Indian Act band councils, it's held collectively by our people. I think that was the one thing I wanted to point out. I know the courts ruled it as proper title holders, but each nation has their way of how the title is held. It would suit, and it's through their clan system. So there's a different way that they hold the title. And I want to thank Russ too for setting out the current context, what they're doing now with legislation and policy. What I was going to speak about was mostly about in BC here, what we're doing with Bill 41. And, it's like a double-edged sword, because we do want the minimum human rights framework for our people that set out the minimum standards. Because I wanted to say that to Sharon, the earlier universal human rights didn't include our Indigenous people. So that's why our Indigenous people penned the United Nations Declaration on the Rights of Indigenous People, but that pen was taken away by the Human Rights Council, and and all the subsequent work that the states have done to not afford us our full and proper rights that we rightly so deserve, because we still are inherent holders of the land. No one surrendered, ceded, or sold or relinquished the title through any of these modern treaty processes. The international treaties, they had agreements that should be honored, and that's the problem with Canada right now, not honoring those agreements. So unilaterally here in BC, the BC government copied the federal 10 principles without any input from any of our Indigenous people here. And then we pushed back. So I know the minister, Scott Fraser, is now saying, oh, these are just draft, but we're seeing them turn up now in different agreements, like the recent Lake Babine agreement. It was copied right in there saying the BC 10 principles. So, are they draft or because they're being used? So we still have a lot of the same concerns on those 10 principles being drafted without any of our input. So and I think Russ pointed out how they're being used. We're seeing them in different documents, both the federal and now the provincial 10 principles. So we are still pushing back on that issue with our leadership. And then the BC government passed Bill 41, the declaration, into law. But we push back, we say full implementation, meaning that, self-determination and free, prior, informed consent, and all of those things that should be in there, because we are just working, like many of the nations across Canada, on child and family jurisdiction, our language, and all those things. They're mentioned in those different pieces of legislation. But I'd like to say the issue is the full implementation of it, because right now, it's a lot of unilateral work continuing by the different ministries on legislation, like environment, for example, that was prior to Bill 41, but there's still, processes, and they're not recognizing, which really rightly so. I think one of the chiefs pointed out today at our meeting, it's about our Indigenous laws first and foremost, and it really should be, because we never vacated our laws when the colonial governments came in. We still, a lot of the nations still operate under their Indigenous laws, but it's just not being recognized by the state governments or the provincial colonial governments. The other thing is the Bill 41 provides for a joint development with Indigenous peoples, an action plan, which we talked largely about today with our chiefs, and then alignment of BC laws with the UN declaration, and that's where a lot of the rubber hits the road, so to speak. And then negotiation of agreements with Indigenous governing bodies, which is an issue, and I talked about that issue with a few different lawyers, and concerning, like, how does that, do we do that traditionally? Like in our nation, it was head of households, and then, they had campfires, and then a lot is being described as divisions, where Tate, who is a historical ethnographer, described it as being like divisions. And I'm going like, well, that really wasn't how a lot of our elders described it. So why are we describing it after a colonial person and his perspective, in describing how we governed ourselves, for example? So, there's issues there. And I think other nations will be seeing that once they start unpacking that kind of who is the governing bodies. And to me, it's the people, because they're collectively the proper title holders, and titles held collectively. And then in February, as we were doing the Bill 41, if you remember, the whole Wet'suwet'en Nation, they were protecting their territory, and they were forcibly removed by the RCMP. I seen the clan mothers, the the grandmothers there being, taken away, by the campfire, by the RCMP. I think it was Frida Houston in that one picture. And I was going like, this is just so wrong. So we hear Trudeau, speaking about, there's no more important relationship than with Indigenous people. And then we hear, our provincial leader here, Horgan, also talking about, the importance of working with Indigenous people. In the meantime, at Wet'suwet'en, our grandmothers are being removed, forcibly removed from their territories. So it was really a eye opener to say, like the federal and provincial governments are still really business as usual with their legislation and policy. So we have a real challenge in ensuring that, that what is self-determination. That means we have the right to our own laws, we have the right to our own processes, and to protect our land and water. And
Chief Judy,
yeah, sure.
can you please explain, and sorry to interrupt, just for the relatives who are unfamiliar, what Bill 41 is?
Bill 41 is BC provincial legislation, which is implementing the UN Declaration. It's called the Declaration on the Rights of Indigenous People, but it's based on the UN Declaration. So that's what the provincial legislation. I think we're one of the first ones in Canada to do that, and that was passed into legislation now. So the real work is unpacking it and implementing it. So we're continuing pushing back the government on that, and it's a lot of work because of the as Sharon explained, a lot of these laws are colonial in nature, and they're protecting the colonial government or the government today, and they're assuming their jurisdiction over land and water and resources, which I think was a issue that Russ brought up, and Sharon, that land, territory, and resources are outstanding issues with many provinces. And in BC here, many of our nations are outside the modern BC treaty process. So it really puts us squarely in an issue, because we've never ceded, surrendered, or sold that that right, that land. So because the Creator said, you can't do that. You have an inherent responsibility toward the lands and the waters, and that's and all of creation. That's why we have such sacred responsibilities to do that. So I think with what we've seen with the Wet'suwet'en and the action that happened across Canada was unprecedented. Yeah. And then in March, after the nationwide support of the shutdown of railways, I think almost a lot of nations did that. We see that now the federal government and the provincial government came together and signed an agreement between the Wet'suwet'en hereditary chiefs and the government of Canada. So we see these agreements, and we also seen the Chilcotin 5-year transition agreement after that court case, and then we've seen that just recently, last week, the Lake Babine 20-year agreement. But I think what I'm understanding now is you really have to pay attention to the wording and the language in those agreements. We're seeing some commonality. I know at the union level, we did do an analysis on those agreements, and they were affected here by the BC 2019 treaty negotiations policy now, which basically re-entrenches the modern treaty process. And then even though it says there's debts forgiven and no extinguishment, you got to watch in the language. It's what we're is still based. I think the concern is it's still extinguishment in many ways. So you have to really be careful with that. And we're still analyzing the more recent agreements to see what the impacts are onto the ones outside the treaty process. Our chiefs today talked about that, those issues, because I think they described it as death by 1,000 cuts. So I know what they mean, because there's so many each line you have to go through, and as even it could mean a lot of different things, so you have to be really careful. And I'd like to say, Sharon mentioned the CERD that we went to in Geneva. I think that was really important to get. They sent a couple of letters to Canada. One was regarding the Kinder Morgan pipeline, which is now owned by the federal government, so they're squarely a conflict of interest there. But they did, CERD did send a letter to Canada, which I don't believe they still responded to them. But it did set out, our rights and, our title and what the elimination of racial discrimination. And so we have a lot of work we're doing on, the impacts to human rights, and I think that's a good amount of work that is being done, and we have to continue that. And then I think in BC, our chiefs rejected that reconciliation framework that Russ was talking about. So
Yeah.
there were clear resolutions at the AFN that rejected it, but we had to do a lot of work to do that. Same with that May 1st and 2nd policy meeting that was held in Edmonton regarding when it seemed like the federal government was just going to come in and, without a lot of our input, reform a lot of these policies that affect us. So, and I agree that we need our own action plans. I think we got to really understand where we're going with this, and it's the continued impacts to our title and rights and our recognition of those rights, and then how we're implementing our own laws and jurisdiction and legal orders on the ground, because those have survived all of the different, governments, and we have to continue that work. But I find nowadays we have a group of younger leadership too. And I really think it's really important to be able to educate and create awareness with our younger leadership on these issues, because a lot might be coming out of the education institutions, and a lot out that just think that's the way we have to negotiate. And these are the basis for negotiating. And this is the principles and values they stand on. So I think the transmission of that knowledge and history is so important. Because otherwise we start engaging in their language and in their domestication of things, and then the result isn't going to be good. And we have to be really clear where we're going. With our council in our community, when we first started together, I just drew on the whiteboard. This is the path to self-determination. It's a bumpy road, but we'll have our language, our jurisdiction, our laws, all of those things, and it's a more stronger foundation in the long run. Then on the other side, I wrote the Indian Act process, and it's a smooth road, a lot of dollars and a lot of things you'll get, but you will not have your language and your jurisdiction and your inherent right and your self-determination. So which path are we going to? And our council looked at both sides, and they all of them 100% pointed to self-determination. But it is a lot of work, and I think we have to understand what components of that work involves. So we are developing our land rights strategy for our community, because it's a lot different than the other nations. But I'd like to say land rights, there's still the economic opportunities, but in some of the nations around Turtle Island have shown that we could still have our land rights and still do our economic components to be, getting what is rightfully ours, and then using it in accordance with our values and our principles. But it's just sorting that out on the ground, and I think you can find a way forward, because in this time of COVID and this time of economic fallout post-COVID and all of the different challenges we have, I think there's going to be some nations that are pointing the way on how we can do this effectively, but it has to be informed. So I hope many listen to this, and that this is played and people can access it to get that information, so they can make informed decisions with their title holders or with their elders and with their people. Thank you.
Thank you, Chief Judy, for that, and for just bringing us to where we are right now, and the actions and the work that is happening today. And thanks again to all of you that are bringing us to this point. We have a little bit of time, and I wanted to allow for an open discussion between all of you amazing people. And one question that comes up is asking, what would you all recommend for Indigenous nations, communities, and peoples at this time as we're going forward, just with everything that you just mentioned, Chief Judy, and just maybe a question, open discussion, and we can take it wherever it goes. Yeah,
I just wanted to add on about the Indigenous laws and governing bodies. I think we're seeing that in a lot of the different pieces that are coming out in regard to what the federal government is doing. But
Mhm.
the anecdote, Russ was reminding me what Chief Arthur Mann used to say: the self-determination is the antidote to colonialism. So that still holds really true today. And it's just getting that information from your knowledge keepers and your elders, and working on your laws, and also the foundation is your language and your
Yeah,
culture and your way of life, and the transmission of that to your people. So I know we have an amazing group of language speakers and knowledge keepers in our community, and they do their own work. They don't rely on chief and council to do that work. They don't recognize Indian Act chief and councils. They just do their work, and I'm really proud of our knowledge keepers that do that. They carry a lot of the continuing our way of life, which is so important. And our elders are
right.
always busy in our nation doing lots and lots of work. So I really respect all of the work that our people do.
Yeah, completely. It's like sovereignty within our own languages and within our own worldviews, and not through this other language that's we have to, as you described it, go through one line at a time, and check to see if they're trying to further remove our rights. Sharon or Russ?
Do you want to go first, Sharon, or?
Thank you, Russ. I really, I agree with Chief Judy, because we don't need anybody's permission. We already have permission from the Creator,
Yeah.
and to do, what we have to do. We have responsibilities, we have obligations, and we have to just carry on doing them. And I remind a lot of young people, like, we don't need anybody's permission. That was residential school. To go to the bathroom or to eat something. We don't need that anymore. The Creator sent us here with our own instructions, our own way of doing things, and we have to just do it. And the land is still there, and the creation is still here, and we still have the responsibilities. We can't give that up to somebody else, because that's what we're here for. And I think what's happening now is that our younger people are waking up to the idea that there's serious problems, with our relations. Our animals are suffering, our birds are suffering, our fish are suffering. The creation is suffering. Look at what happened in the southern part of Turtle Island with the fires. Why
Yeah.
are those fires burning like that? It's because they were not respecting them, and so they said, okay, let's just fire spirit said, okay, let's just take it down. Like, people might not be happy to hear that, but these are very powerful spirits. Like the wind is a very powerful spirit, and we have to know that, because we live with them, and we can talk to them, but we can't just pretend we're not responsible.
Yeah.
And so when we went to the United Nations, in 72, the old man, from the Hopi, he spread white cornmeal on the ground. So when people walked in with the pipes, that was the first ones in, was the cornmeal and then the pipes. So our spirituality went first into that building. We didn't go there in some kind of white man's business way of doing things. We followed the spiritual directions, and followed by the drum. So we took our law with us. We live our laws, and I think that's what Chief is talking about. They don't need to go to the Chief and Council and ask them, can we speak our language? Moin skate in, you're going to say the Chief and Council are going to tell you. I don't understand why you're asking us that question, because we didn't give you the spiritual gift of language. It came from somewhere else. So I think we have to remember that, because so long they have been trying to get us to forget that. And so we have to remember it again, and work on it.
Right.
But I always say that as long as we have the land, the language will come back, because the land will tell us the language, and it'll teach us the right words to use. And so, I think There's a lot of work we have to do. Forget about what the colonizers are doing, because the colonizers going to do what they're always doing. We have to work on our own schedule, is what Russ was saying. We have to have our own plan, and we have to just get on it and do it. I think too often we come up with great plans and then we sort of drop them.
Yeah,
We need to get on the plan and just keep going.
just do it.
I just want to add one little thing, because I don't think people will know this. When they moved the declaration into the General Assembly, and they disbanded the working group on Indigenous peoples, at the same time they stopped all the work that we were doing on elaborating rights relating to land, elaborating rights in relation to treaties, elaborating rights in relation to intellectual property. We are elaborating rights in relation to mining rights. We're elaborating rights on resource access. We're doing a lot of work within the working group on all these different standards that could be dealt with within the UN system. And what they did is they stopped all that work in the UN system, and that has never been taken up again. And we need to re-engage someplace, somehow, some of that work, because they had some really important studies that were done, and they have just dropped off the wayside. There's a lot of people that have a lot of guilty minds. And when they go to the Creator, and the Creator asks them, what did you do to help your people? What did you do for the future generation? Mucky Quay, they didn't do anything. They'll have to pay for that. Not for us here, but for them. They have to think about those things, because they're going to have children, grandchildren. They got to think about it. I'm not saying that to be mean. I'm saying that because that's our laws.
Right.
And we have to think about that. So all of us have to think about that all the time.
One of my lectures, he says, we are the ancestors of tomorrow.
Yes.
Right? Like, it's everything you guys just said. It's our obligation to do these things right now. It's our obligation to, reestablish those relationships to the land, take care of the land. And like you so beautifully described with the fires, that there's a message there. Is paying attention, to being able to listen, and to honor those obligations. We are the ancestors of tomorrow. Like, we have to do work today, right now. It needs to be done. Thank you, Sharon.
Thank
Russ?
you.
So, yeah, so, as the policy guy, the policy wonk here, I look at things from a practical point of view.
Mm-hmm.
And what I've been saying to different leaders and community people is, we have to develop our own self-determination plans. Because right now, what Canada's been doing, what the Trudeau government's been doing, is they've been operating in a top-down, secretive fashion, using the national Indigenous organizations, the Assembly of First Nations, the Métis National Council, the Inuit Tapperas of Canada. They've been using the three national leaders, the three national organizations, plugging them into the cabinet in what they call bilateral mechanisms. Give the impression that policy and law changes and the changes in the structure of government are all jointly developed. That's the term they use, joint development. But that's false, because the federal government controls the funding, the pen, and the agenda.
Mm-hmm.
So how do you counter that? Well, you counter that by, first of all, the courts have said the burden of proof is on us, that we have to prove we have Aboriginal or treaty rights. It's not fair, but that's how the Supreme Court of Canada is laying it on us. And that's how come we're faced with injunctions and police action all the time as soon as we set foot onto our traditional territories to do anything. And we bump up against a settler interest, a corporate interest, a third party interest, a homesteader, or, a settler, or a government, and you wind up in court. Right now we have land defenders with the Tiny House Warriors in BC, the Haudenosaunee land defenders at Six Nations, the Mi'kmaq fishers out there going after lobster out in Nova Scotia. They're all outside of the framework, the national framework that Trudeau is trying to put everybody into. I say it's like the Indian Act is the old decrepit jail cell. They want to move us from that jail cell into a new modern jail cell with a kitchen and everything, but it's still a jail cell.
Yeah.
That's what self-government is compared to the Indian Act. So how do we fight that? Well, we have to fight that, as Sharon and Chief Wilson said, we have to retrace our steps, our research, our history, our language, our culture, the original instructions the Creator gave us. We have to collect that information. That means we have to be better at, and the younger people are good at this. We have to learn how to have libraries and archives, you know, our own. Our elders used to be our libraries and archives, but we have to merge that oral history and the traditions in with using these modern tools, like computer mapping. But we need to collect our history, pull that together, and then in addition to knowing our history and culture, our language, our laws, we have to know what the provinces are doing in our territories and what the corporations are doing and what these third parties are doing. So we need to get that information and put that on into the computer. We need to know how to do information management. And we have to have information management systems to make our own plans. And our plans are going to be in conflict with the province's plans because they're making plans. They're making long-term plans for forests, vines, dams, roads, hunting, fishing regulations, you name it. We have to collect our own information to counter that and start demanding on how we want to see our territories managed. But that means we have to have that information, and we also have to have the skill to interpret it, you know, from our oral history side. But we also need to know the values of these things. You know, that's what Art Manuel was working on before he passed, was, you know, how to value what Aboriginal title means. And not just economically, but environmentally, to be stewards and manage our territories, you know, to use it, but to protect it too, in sustainable development. And that's where we also need to have the advisors to help us negotiate this constitutional law and this international law that they're using on us, so that we don't sign agreements that are going to affect future generations. So we have to navigate through all of this information, legal, political, environmental, social, economic, cultural, and we need to do that. And we need to start thinking in larger scales. The problem is the Indian Act ban system really was to dismember Indigenous nations. You know, down in the US, you guys have, certainly west of the Mississippi, you have large reservations. Up here in Canada, they just created small little reserves and put a ban on the reserves. And the idea, now we have 630 bands across Canada, but they make up the 60 some Indigenous nations. But that's why I'm saying they're negotiating deals band by band. That's how you extinguish an Indigenous nation, is we don't get together in the larger assemblies, most of us. Some do, but not all of us. And that's where our people, you know, I keep reporting, you know, there's some things in the declaration we can use, like Article 18. Article 18 says we should be making decisions through our own Indigenous institutions and through our own procedures. Well, Indian Act band councils are not, Indian Act bands and band councils are not Indigenous institutions. They're colonial institutions under the Indian Act. We need to start knowing how to gather and to meet through our spiritual, cultural protocols to bring the people's voice back into decision making. Because it used to be when the Indian Act was imposed, they had an Indian agent. Well, in a lot of ways, the chief and council, when they get rid of the Indian agents, when they got the chief and councils to start signing funding agreements to deliver programs and services, in a lot of ways, they replaced the Indian agent, because Ottawa's still designing the funding and they're still designing the programs. They're still doing the social engineering, moving us in the direction they want us to go.
Yeah.
Some band councils are smart enough to realize we have to have a double agenda. One where we take the money and do the reports and give Ottawa the reports that they want. But on the other hand, we need to be working on our own plan as to who we are, and to come up with a long-term plan and basing it on that information collection I'm talking about. And a lot of our people aren't too good at doing that yet. The younger people are getting skills. So that's where we need to bring the elders, the women, the youth together to tell the leadership, we need to do these self-determination plans, and this is how we do it. And if you don't have the expertise in your community, you need to find people you trust that can help you navigate that. That's how I see their survival of us as distinct organized societies. Otherwise, we're going to become what Trudeau wants, which is ethnic municipalities. And that's where the trend is. Of the 630 bands in the country, over 400 are compromised at one of Trudeau's what I call termination tables. And most of their people don't know what's going on because these are secret talks. So we need to bring some light into what's going on. And if termination's on the table, we should get out of the table. But it's easy to say we don't like this.
Yeah.
We're not as good as saying, okay, this is what we want, because we need the information. I always say free, prior, informed consent means informed, means information. People are afraid of change. If you don't show the people, we have a plan and it's based on this information. And here's our options. They're going to feel more comfortable about making a change than if you're saying, just sign this agreement and trust us.
Yeah, exactly. Well, thank you, Russ. And I just want to again extend my gratitude to you all for taking some time to come join us on this conversation. And I think to accomplish exactly what you just said, Russ, is spreading that awareness, that information, right now. And hope, sorry, go ahead, Chief Judy.
Yeah, I just wanted to say I was talking about the UN Declaration quite a bit today, and I was talking about it with our Grand Chief, Stuart Phillip, and he did a quote to me, and he said I could use it, so I want to use it. He said, just because the truth doesn't square with your reality doesn't make it untrue. So I think that's what we're talking about is, how the colonial and state governments have years and years have been using legislation and policy against us, weaponizing it. We see that. We'd like to think that Trudeau's nice words were reality because of racism and discrimination and all of those things, his famous Valentine's speech. But reality on the ground, what are we giving up in regards to asserting our obtain what we think are we're obtaining our title rights and our jurisdiction and things like that. So I think it's really that quote really resonates. We have to be use our due diligence and caution in what we're doing. And I do like how we arrived at a discussion that said we have to do our own plans for self-determination, and we have to do it collectively with our people. And I like the way Sharon said, the language is on the land and we're part of the land. So we'll continue on our work as we have done since time immemorial. And, with all these changes with COVID and the economic landscape and years to come, possibly, we're dealing with this new way of life, that we can bring in our Indigenous systems, our Indigenous knowledge, because that's been sustainable throughout mankind, not these commercial systems or colonial systems or state systems that don't last. So we're looking at how we survive in the long time. And it has to have that economic foundation to it too, because our people did know how to manage the economics of the day, just like with Chief Arthur Manuel working on the valuation of title and rights. I think that's an important part. Our chiefs talked about it today and how much we consumed in salmon, how much we consumed in deer and moose, and because that was all important to our diet and our survival. But there's the economic component or the valuation of that. So I think Chief Art was on the right path. I remember being at that conference on valuation of our title and rights, and I think it's important work to continue. So I applaud all those nations that are doing some outstanding work, and they're finding a way forward. Thank you.
Thank you, Chief Judy, for those words and that quote that fits so right. Again, thank you all for joining us this evening, and again, thank you to all of the relatives that are tuning in across our lands, into this discussion, and we will be back with more covering a wide variety of these topics as they pertain to, you know, our Indigenous rights, our self-determination, and our within our worldviews. So again, thank you to you all, and everybody have a good evening.